If you're heading into a domestic violence hearing and you do not have a plan, the odds are stacked highly against you. Now, courts do not hand out protection orders just because you say something happened. The court needs evidence, and they need it presented in the right way. How to prove domestic violence in an order of protection or custody case. I'm Kyle Kaufman. I'm a family law attorney in Wisconsin, and for now almost 20 years, I've represented victims in these cases, and I've seen how easy it is to lose when you're not prepared. I've also seen how powerful a well-prepared case can be, and that's what you want. So in this video, I'm going to give you my 5-step framework for proving domestic violence in an order of protection hearing or in a custody case. Step number 1, start by writing down every detail. Memories fade, so write it down. Write everything down. And when you're dealing with trauma, I understand that it's easy to forget details or push them aside. You just don't want to think about it. However, in court, details matter. I have found that judges make decisions based on facts and not feelings. And the more detail that you can provide, the better your outcome will be. So write out everything that happened. Who was involved? What exactly happened? Where did it happen? When did it occur? Why was it happening? And how did it unfold? Take the visions and thoughts and feelings that you have in your head and put them on paper. Don't gloss over anything because you think it's too small. Often, what victims think is minor turns out to be a really crucial piece of evidence. So tell the story. Specifics build credibility. Saying it happened sometime last year is weak. Saying it happened on April 3rd, 2023 at 5 p.m. outside my mother's home is much stronger. The more precise you are, the more believable you become. Step number 2 is you want to use a structured plan to organize your story. When I work with clients, I use what I call a safety-focused parenting plan. Now, this document asks really hard questions about abuse, and I'm talking about physical, emotional, sexual, financial. And it also asks questions about threats, mental health issues, and substance abuse. Why do I do this? Well, I do it because victims often normalize abuse. They think, this is just how life is, I'm used to it. They don't realize how serious it sounds to the court. Now, by forcing my clients and people like you to answer these questions, you uncover facts about what you might have overlooked. An attorney sees that and it's something different and useful in your matter. If you're representing yourself, create your own version of this form. Write out every incident of abuse. Start with the 5 W's. Who, what, where, when, and why. And after reading that out loud, that helps you to catch the missing details and it makes it easier for you to tell your story later. Step 3 is for you to gather every piece of evidence you can. What I have found is that documentation wins cases. Courts believe evidence they can see, hear, or read. Your testimony matters, but it's stronger when it's backed up by proof. Here are some things that you will want to collect in your case. Number 1 is witnesses. Now, these are people who saw or heard the abuse. This could be neighbors, it could be friends, family, police, medical staff. You want to gather documents. Documents such as police reports, medical records, photographs of injuries or damaged property. Another item you want to collect is digital evidence. We're talking about text messages, emails, voicemails, videos where threats or abuse are clear. You can hear them or see them. Now, organize everything you have, make a list of what you have and what's missing, and then go after those missing pieces. Go out into the world and collect them from the source who has them. When you use evidence in a case, you make sure it's clear and easy to understand. Don't hand the judge a stack of unorganized papers or scroll through your phone in court. You want to print it, you want to label it, use it as evidence, have copies for the judge, the other side, and yourself. Step 4, I want you to prepare your case and witnesses, okay? Now that you have your story, you have your evidence, you need to prepare how you'll present it. You want to use discovery when you can. In custody cases, you may have time to send interrogatories, requests for admissions, and requests for documents to the other party. You're specifically asking them questions and asking them to respond. It forces the other side to answer these hard questions or hand over the evidence that they have. Now, sometimes they can even admit things that can help win your case. You also want to use subpoenas to bring reluctant witnesses into the courtroom. You often might have people that say, I don't want to get involved. But if they have crucial facts, they're a witness and they need to testify. And a subpoena can legally require them to do so. You want to practice your testimony. I tell clients to testify like reporters. That means stick to the facts, stay calm, explain what happened clearly, avoid getting lost in your emotions. That's easy to do. It's easier said than done. But because your emotions can really distract you from the facts that you need to prove, so make sure you're telling the facts. And then for each witness, you want to identify the 1 or 2 key elements that you want that witness to really confirm. Why are they there? What can they tell the court? Don't call police who only repeat what's already been said. Bring the ones who add something new or something important to the story. The fifth step for you is to present facts that the judge cannot ignore. When the hearing starts, your job is to funnel the facts that you have to the judge in a clear and organized way. Every witness, every exhibit, every word that you say should help the judge understand what happened. If the abuser is lying in court, use your evidence to expose it. If the abuser contradicts themselves, point it out with your evidence, with your witnesses. Remember that judges are making decisions based on what's in front of them, what they see, hear. If you don't present a fact to the court, then it does not exist in the court's eyes. They can't use it to make a decision, and you don't get another shot. So here's what this looks like in action. I had a client, and this client had a lawyer who had really failed her. She ended up co-parenting with her abuser because no one presented her case the right way. It's the bottom line. When this client came to me, we followed the steps that I outlined here. We wrote everything down. We organized it. We gathered the hard evidence, and then we prepared every detail for court. When we presented our case to the judge saw the full picture and granted the protection that she needed. And that's why this framework matters, and I know that it works. It gives you control over the process and certainty. Domestic violence cases are emotionally draining. They're very difficult, but preparation gives you that certainty and that power that you need. So follow the 5 steps. Number 1, write down every detail. Number 2, use a structured plan to organize your story. Number 3, gather all your evidence. Number 4 is prepare your case and witnesses for what they're going to say and what you're going to show. And number 5 is when you're actually in court, present those facts and that evidence to the judge so the judge cannot ignore it. Do this, you'll walk into court feeling prepared, and you'll have a case that's hard to deny and a far greater chance of walking out with the protection that you deserve.